Hey everyone, law school's about to start, so besides what I have previously recorded for the pre-law, in other words, what I should just say is all my pre-law content is going to be edited. But starting now, you're going to get raw footage of what law school is like. You're going to get all the bangs and thumps on the table that I typically edit out for the pre-law stuff just because it can be kind of annoying. And you're going to get the raw footage from my study sessions. But since law school is about to start, orientation has started to happen, or at least pre-orientation has started to happen, and I've done several modules to prepare for orientation. At least that's what Drake has wanted me to do, and so I've done them, and I've taken my notes on those modules. And the next few episodes is going to be specifically about orientation, and I'm just going to review my notes in my head so that you can hear them, and so that I have a verbal way of reviewing my notes. Whether I'm in the car, I can just listen. It's going to be a bit weird to listen to myself while I'm in the car, but that's what's going to happen, just so that I can review and study when I'm not necessarily reviewing or studying. Okay, so the first section, I've done all these segments already, but I'm going to go over them again and just look over my notes while I share what I learned from these sections. The first section was talking about the types of law that are done. In this section, my notes came from the book, What Every Law Student Really Needs to Know. It's by Tracy E. George and Susanna Sherry. And it's a chapter in the book. I believe it was chapter 4. Types of law that it talks about is adversarial versus inquisitive. Most countries, the United States is different from most countries because it follows an adversarial approach, meaning the lawyers are arguing in behalf of their clients. It's more of a debate. Most other countries use the inquisitive approach, which means that a judge is highly involved in the research. He's an active participant. And the other big difference between adversarial and inquisitive is adversarial relies heavily on juries, while inquisitive relies heavily on judges. It is important to note lawyers are present and discussing for inquisitive, but they are not a major deciding influence like it is in the adversarial approach. Okay, then you have common versus civil law. Common law is derived from England. It just means what's the custom understanding or the common understanding of what the law is, and we're going to use that to influence our decisions. Civil law is based solely on statutes. If there is no statute in place, it's like, okay, so what's a broader statute that we could use to review this? The United States mostly relies on common law, but it does also have to deal with statutes because, there is a constitution and statutes that are based off of it. Okay, private and public law. Public law is often just meaning a governmental influence is one party against a private party, or such as a company or individual. And then private law is when a company or individual privately sues another company or individual. So substantive versus procedural law. I have to review this real quick. Just give me a second. Oh, this part came from one of the orientation videos, not the reading. This wasn't part of the reading, but still discuss it. It's important. Procedural law covers how to use the system, meaning what are the rules, what are the methods, what's the procedure, and then using that to influence decisions, like how much should we charge this person, how does the court run, how should we gather evidence, that kind of stuff. Substantive law, on the other hand, discusses how people behave and the public norms. For instance, this talks about what the crime is, and does so by describing the intents of the individual creating the crime. So those are the types of law. Now we're going to transition into the courts. There are trial courts, Court of Appeals, the Supreme Court, and a lot of and this follows both the federal and a state system. It's often parallel. I think another module also talked about this, but trial courts, they differ by what state you're in as far as their name goes, but they're most commonly known as the United States District Courts. It's the lowest court system. It's the only court where a trial jury, where a trial with the jury is present. They're different from municipal courts, probate courts, and they're because they're just different because I think it's the relation of how it goes between the state instead of the federal jurisdiction. So each state has at least one district court, and as many as 4. Iowa, the state I'm currently in, has 2 district courts. There's Court of Appeals, or these are also known as circuit courts. There are 12 geographical circuit courts. I believe Iowa is in the 8th Circuit Court. Depending on what trial court you're in, also determines what circuit court you're going to be taking place in. The Supreme Court is the largest court. If you're not satisfied with your case in the trial court and then the appellate court, the Supreme Court has the ability to review, which is different. They can choose which cases they're going to review, while a lot of circuit courts don't have that choice. But again, there are some mandatory cases the Supreme Court needs to review, such as disputes between states, or when they have original jurisdiction, such as foreign treaties and things like that. Foreign affairs go automatically to the Supreme Court. There are different kinds of litigation. It's quite different than what most lawyers assume litigation is like, because it's not quite so dandy as everyone thinks it is, because the trial part isn't most of litigation. What happens most of the time is the parties settle, or if they don't settle early, they'll probably settle during discovery, because the evidence, just because it gets expensive. But if they decide to go through, only about 2/3 of the case are decided by a jury. The other third, a judge can decide a case, or the parties may agree to not rely on a jury. So in total, about 1.5% of civil disputes ever see a courtroom. Criminal cases, about 90% actually make a plea deal, so about 10% ends up going to the courtroom. Ways to remedy if you're found guilty. There are monetary remedies, which are known as damages, and there are equitable remedies. Equitable remedies are like orders. So protective orders, injunctions, things like that, that tells a party you need to do this, meaning, or you can't do this. So, for example, you can't build this fence here, and I order you not to build this fence here. So, takeaways, there's lots of types of law, and there's these court systems and litigation and remedies for those court systems, and that's the first segment of orientation. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is, if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice. And with that, the fourth thing is if it is used as legal advice, we are not liable. That is, law scholars is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.